Thank you. Thank you so much. My name is Francisco Gonzalez. I'm the Vice President of Advancement for the James Madison Institute. I want to welcome you here, or maybe you're welcome me here to FIU. Really glad to be here. For those of you that aren't aware, the James Madison Institute, our headquarters are actually in Tallahassee. And despite the name, we actually are just focused on Florida public policy. We're not in Virginia or DC or anything like that. But we do, live in a state of Florida that has national implications, and so we do field a lot of questions from people all over the country about what's happening in Florida. What are you guys doing on this issue or that issue? And so it is an exciting place to be. And as you know, we're about to pass New York as the third largest state in the union in the next couple of years. So it's an exciting place to be. But while we focus most of our effort at the Institute on public policy efforts, that's why we're in Tallahassee, to have an impact on what goes on in state policy. We also have a robust civic and economic education program for young people, including middle school students, high school students, and college students. And so this is part of one of our college programs called the American Cause Seminar Series. This program has actually started up at FAU, which is actually my alma mater, up in Boca Raton. And I'm going to introduce in a second one of the professors that has started it there, Marshall DeRosa. But we are now, based on the success there, we've now expanded it to FIU. So this is the first in the series, and we're especially glad that Professor Foley could be part of this and help us. And hopefully, we've now roped her in, and she's going to hopefully be helping us for a long time, I hope. So anyway, I want to just thank you for being here. If you want more information on the James Madison Institute, our website's pretty simple, jamesmadison.org. Got all the Twitters and hashtags and everything going on. So if you want to tweet about what's going on here, you can. Our Twitter name is at JMSMadison, INST. You can also hashtag JMI. So whatever we'll follow that. Maybe we'll retweet you. But we also, before you leave, there's a little card right in front of you. If you want to stay connected with what we're doing, the card is actually provided by an organization we work with that works with college students all over the country called ISI, Intercollegiate Studies Institute. I actually had the pleasure to work for them for a few years before I came to JMI. But they provided much of the material here, and we didn't have enough books because we didn't expect this much turnout on the first session. So we will they actually will mail you like a little packet of a couple books. A few of them are here, but they're not all here. I also have some journals from the James Madison Institute here. If you want to see kind of what's going on, we do a smattering of issues for every journal. So anyway, take everything here while it lasts, constitution guides and everything. But for now, I want to introduce Professor Marshall DeRosa from Florida Atlantic University. Professor DeRosa, he got his PhD from the University of Houston. He's a political science professor at FAU. He's involved with different groups and is author of a number of books, including a most recent book in 2007 called Redeeming American Democracy. Most of his interests include American jurisprudence, federalism, and civics education. And we're really just honored. Professor DeRosa is also on our Research Advisory Council and has led the effort the last few years to do this kind of program at FAU. And we're honored that he spearheaded that, and now it looks like it's taken off to other campuses. And I'm glad he made the drive down today, because we know it's not easy in that traffic all the way from Palm Beach County. So thank you, Professor DeRosa. Come on up here.
Okay, let me echo what Francisco said. It is a real pleasure and honor to be here, especially working with Professor Foley. Let me, just a disclaimer, because we are not an indoctrination organization or program. I've been teaching political science for quite some time, and I know something about higher education. And I became frustrated with the fact that students weren't getting all perspectives across the ideological spectrum. And even though this card says that you're going to be filling out if you want a nice packet of books and some literature from the Intercollegiate Studies Institute for thoughtful conservative students, it's not only for conservative-oriented students. It's for anybody who wants to engage in the world of ideas and the marketplace of ideas. So wherever you are on the political spectrum, anywhere from libertarian to socialist, it's good to know how other people along that spectrum think. So you can consider those ideas and make sort of a good judgment as to what might be the proper public policy, or in your case, what is the proper jurisprudential approach to the American legal system. So with that said, if you fill out this card, it doesn't mean you're a card-carrying conservative or libertarian. What it means is you just want to read some literature and some really good books from people from that side of the political spectrum. So I encourage you to fill it out and be sure to include your email address, and you'll get a nice, within a couple weeks or so, you'll get a nice box of books, literature, journals to consider, look at over the holidays, read, or use as Christmas gifts for your conservative libertarian friends. So everybody's a winner. With that said, let me introduce, and this introduction's for, you all know Professor Foley, of course. This is for the people that will be viewing this online. Elizabeth Price Foley is a professor of law at Florida International University College of Law, where she teaches healthcare law and constitutional law. She is the author of The Tea Party, 3 Principles, 2012 from Cambridge Press, The Law of Life and Death, Harvard University Press, 2011, and Liberty for All, Yale, 2006. Professor Foley served on the Committee of Stem Cell Guidelines of the Institute of Medicine, as a Fulbright Scholar at the National University of Ireland Law School, and as a health policy advisor on Capitol Hill. She is a member of the editorial board of the Cato Supreme Court Review and the Research Advisory Council of the James Madison Institute. So, Professor Foley, the floor is yours. Thank you very much.
Well, thank you so much for coming tonight. I know a lot of you are my students, and I kind of not so subtly coerced you into coming. But I did so with a good heart, in the sense that I think that you will get a different perspective from what I'm going to say tonight. I think that's valuable to you in your education. And there's some things, some important topics related to constitutional law that you know, as part of our monolithic constitutional law course, we don't have time to get into. And I think this is one of those aspects. So not only will perhaps it help you understand the constitutional law that you're studying now, but also your international comparative law course that you have to take here. So thank you, first of all, to James Madison Institute, to Marshall, to the American Cause for sponsoring this event tonight. I think it's great that they provide this kind of forum where college students and graduate students can get together to talk about sort of controversial issues in a way that you don't feel the same pressure. I hope you don't feel any pressure that you might in a classroom, right? Because when the professor is talking to you in a classroom, you may feel like you have to parrot the professor back or something like that. I hope you never feel that way in my class. I certainly hope you don't tonight, because I'm going to try to reserve as much time as I can so we can mix it up with each other and have some back and forth and some sort of fun, intellectual debate, which is what makes law school great. I remember when I was in law school, I loved events like this because I finally got to really get into the intellectual nuts and bolts of things that we didn't really seem to get into in class. So let me talk about the topic for tonight, just kind of give you a broad overview of where I'm going to go with this. And I hope I'm going to say some provocative things along the way that you're going to want to at least try to fight me with a little bit so we can all learn something. Okay, so the topic is American exceptionalism, and then you always have to put a colon in everything that's academic. Sovereignty and the role of international law. And you may say to yourself, what do those things have to do with each other? What does American exceptionalism have to do with sovereignty, which has to do with international law? Well, obviously there is some important relationship between all three of these things that I'll try to talk about tonight. But more importantly, I picked this topic because of where you're at. Right? Think about where you're at right now. Not only you're in law school, congratulations, that's fantastic, but you're in a law school that uses the word international as its middle name, right? And not only are you at Florida International University, but you are required, one of the things we tout at this law school is that we're different, we're special, we're unique, because we require you to get a little exposure to international comparative law topics in all of your core curricula. And then you're required also to take this special class that most law students don't have to take, international and comparative law. So there's clearly something about this institution that is telling you that international law is important, that you as a young lawyer and a future professional have to pay attention to international law. And I think that, you know, it's interesting that you're told constantly to think globally, right? Isn't that one of FIU's slogans these days, think globally or something like that? And, you know, you're supposed to be a citizen of the world, right? We keep telling you, whatever that means. And all of that is fine and good. It's not like I'm going to stand up and say, I don't want you to think globally. I want you to be myopic and, you know, only look at what's right in front of your feet. But I do want you to think critically about international law. And if you're not given exposure to a critique of international law and some of its darker interstices, then I think that's a real shame for your education. So I'm going to ask you tonight to think critically about international law in various ways that you may not have been asked to think about in some of your other coursework. And so in the end, you may not share my concerns about international law, but I hope that you will have a better idea of some of the concerns that people have, like myself, and be able to better defend your own position, even if it's different from mine, okay? Okay, so let's talk about exceptionalism, first of all, because I think this is a word that a lot of people don't understand, right? Exceptionalism doesn't mean, it's not synonymous with better or superior, right? If you look up exceptional in the dictionary, what it will say is uncommon or unusual. So when people talk about American exceptionalism, and I'm a person who strongly believes that America, the United States, is an exceptional country, we don't mean that America is better than the rest of the world or superior to the rest of the world. What American exceptionalism means is that we believe there's something unusual, something uncommon about this country. And what I think is unusual and uncommon about this country is that we have sort of an exceptional legal system, an exceptional governmental structure. And I think that that legal system and that government structure is worth defending and promoting, frankly, to the rest of the world. So think about our remarkable history, right? It was we the people. We had a formal Declaration of Independence from Great Britain. We wrote it down. We tried to persuade the world and show them that what we were doing we thought was just. And then we got together, we the people again, as the beginning words of our Constitution, and we wrote and ratified a Constitution in our name, right? That's unusual in the history of the world. That's important. That's exceptional. And because of that history, what we've done is we've lived under a remarkably stable rule of law for over 225 years. That's unusual. That's uncommon in the history of the world. We are, in fact, a nation of laws and not men. And what that means is we care about process, not just outcomes. That we think the way we get to a decision matters, and it's not all about achieving a certain desired end. I think that's uncommon, and that's worth preserving. It's exceptional. But international law has begun, I think, in the last half century or so, to be viewed as a means to desired ends by certain people. And they want to impose certain desired outcomes, not on just a distinct political community, but on the globe writ large, right? And I don't think it's any secret that most people who go into international law, certainly people who teach international law for a living, buy into the internationalist agenda. And they are generally politically progressive, left of center. And they see international law as a good means to achieve their desired ideological ends. And I think as lawyers in particular, but any type of American, I think we need to be aware, at least aware of the presence of this agenda, this desire, and ask ourselves whether internationalizing law, kind of like nationalizing law within our federalist structure, whether internationalizing law, globalizing law is wise for us as a people for our own freedom. And I think sometimes the answer may be yes. It's not uniformly no. But a lot of times the answer is going to be no. So let me be clear about this. I do think there's a proper place for international law. I'm not standing here and saying, oh, there's no such thing as international law and it should never, ever be implemented. That is not what I'm saying. International law sometimes can be used to accomplish very positive things, and sometimes international law can be very much in our national interest, right? But not always. So the question is, how do we discern the good uses of international law from the bad uses of international law? What is the dark side of international law? I feel like Darth Vader when I say that, but in its darkest form, right, international law can be used to undermine U.S. sovereignty, it can be used to create a democratic deficit, and it can pose a very real danger to international freedom. So let's start at the beginning and talk about what international law started out being and what it was understood to be by our founders. The Romans developed an idea of this thing called the law of nations. You probably heard about that, right, in your various courses. It's kind of hard to start an international law course without talking about the law of nations. And we, the people, when we wrote and ratified our Constitution, we in fact included 3 distinct provisions in our own Constitution that recognize that we as a people agreed in the participation of this law of nations as it existed at the time of the founding. So you look at Article 1, Section 8 of the Constitution. You all remember that. That's the portion of the Constitution that gives a little laundry list of all the powers that Congress has, right? And one of those enumerated powers in Article 1, Section 8 is the power to define, and punish offenses against the law of nations. Okay, so there's explicit constitutional text mentioning, referencing the law of nations. Then you look in Article 2, Section 2, which is the presidential power, and what you see is the president is given the power under Article 2 to make treaties, provided he gets the concurrence of 2/3 of the senators present at the time of the vote on concurrence. So the president and the Senate combine to have this treaty power under Article 2. And then finally, the third provision, you got Article 6, our old supremacy clause that we've read a lot in con law class. And what that says is that the Constitution, the laws, and the treaties that are made under the authority of the United States shall be the supreme law of the land. Okay? So it's clear from these 3 constitutional provisions that the founders not only knew about the law of nations, they accepted the law of nations, and they allowed for future development of some form of international laws in the form of treaties, right? So the key question for U.S. law is, what was this law of nations? What does that mean? What body of law does it refer to? And what kind of power is this treaty power that's referenced in Article 2 that's shared between the President and the Senate? And to answer these questions, you probably have done some reading, or at least I hope you have in your international law class, on writers like Hugo Grotius. Sound familiar? Nobody's shaking their head. No? You haven't read Hugo Grotius? You have. Good for you, but you're not a student. All right, write this down. No, I mean, but you'll see the video. You need to read Hugo Grotius. He wrote The Law of War and Peace in 1625. It's like the seminal work on the law of nations. And then a guy named Emmerich de Vattel. Vattel, have you heard of Vattel? Ringing a bell? Not? Vattel's not ringing a bell? All right, he's got a big book called The Law of Nations or the Principles of Natural Law. That was 1758. These are the 2 big works that were in existence at the time of the American founding. These are the 2 big intellectual lights that the founders read and based their understanding of the law of nations on. And if you look at Grotius and Vattel, what they write about in these big books is a body of law that governs relationships between nations, right? It's a law of nations. It's nation-to-nation agreements and law. And so this law of nations is a body of law that inherently recognizes the sovereignty of the nations that agree to the law of nations. So what does the law of nations consist of then, if you read these works? One huge body of law under the law of nations is the law of war, right? You probably talked about, there's a lot of modern iterations of the law of war, but these old school things talk about the use of aggression, the proper use of aggression between nation states. There's basically sort of a harm principle that is supposed to govern nation states. They're not supposed to act aggressively against others unless they're provoked, et cetera, et cetera. So the law of war is a big chunk of the law of nations. The other chunk are treaties, right, between sovereigns. And treaties were conceptualized as contracts between nations, One nation agrees to do something else with another nation, and they enter into a contractual provision. Now, both of these aspects of international law, the law of war and treaty law, presuppose the continuation of nation states as sovereigns, right? This is not a let's all get together in a global hug and a global kumbaya and agree to cede our sovereignty to some extra sovereign international global body. The law of nations, as understood and embraced by the founders, did not embrace or envision a loss of sovereignty of nation states, and it certainly did not envision that we would cede our lawmaking ability, our sovereignty, to some higher sovereign global power that could enforce some sort of international norms. That was simply not part of the picture at the time of the founding of this country. So this modern idea of using international law to create a monolithic, higher global sovereign is a very recent development. And I'm talking about the last 50 or 60 years or so. This is not something that was even thought of by the founders. So let's talk about this treaty power that we have clearly mentioned in Article 2 of our Constitution. I think that's really misunderstood. I'm going to read to you a provision of the Federalist Papers. It's Federalist 75, and this one was penned by Alexander Hamilton. And in Federalist 75, Hamilton is talking to the American people who are considering ratifying the Constitution about this language in Article 2, Section 2, about that treaty power that he's given to the President and the Senate. And he's trying to explain what this treaty power consists of. So here's what he says. He says, the essence of the legislative authority is to enact laws, or in other words, to prescribe rules for the regulation of society. While the execution of the laws and the employment of the common strength, either for this purpose or the common defense, seem to comprise the functions of the executive magistrate. But the power of making treaties is plainly neither the one nor the other, neither legislative nor executive. It relates neither to the execution of the subsisting laws nor to the enaction of new ones, and still less to the exertion of the common strength. Its objects are contracts with foreign nations which have the force of law, but derive it from the obligation of good faith. They are not rules prescribed by the sovereign to the subject, but agreements between sovereign and sovereign, right? So that's what Hamilton sold us as a bill of goods as to what the treaty power meant in Article 2. So if you parse that provision carefully, there are really three things that you get out of that passage from Federalist 75. One is that treaties are contracts, right, between nation states. Number two, that treaties can be enforced only by an obligation of good faith and nothing else. And number three, that treaties do not prescribe rules by which citizens have to adjust their behavior, but rather are rules that must be obeyed sovereign to sovereign. They relate, in other words, to external sovereign to sovereign relationships rather than sovereign to citizen or internal domestic matters. So, in other words, treaties are clearly not a substitute for domestic law. The treaty power is exceedingly narrow in scope. As James Madison put it in the Virginia Ratifying Convention, he said, quote, "The object of treaties is the regulation of intercourse with foreign nations and is external." Right? Now, once you understand what the founders thought they were giving to the President and the Senate in Article 2 and the treaty power, and once you know what the law of nations was, you can gain a better appreciation, I think, for this battle that's going on right now in your generation over the scope of international law. This is a heated contest. And it's an important shift. Think about the shift that's occurred between the law of nations and what you're now studying, which is international law, right? First, think about the subtle but important language shift. Just the language shift alone. From law of nations to international law. One presupposes relationships between sovereign nations, law of nations. One presupposes some sort of body of law that supersedes or is somehow higher than nation states themselves and is international in scope. That's a very important shift, and I think it's telling. Because modern international law is not satisfied with nation-to-nation contracts governing purely external matters like what kind of chemical weapons we're going to use and store, about what kind of protection of diplomats we're going to give to each other while they're in our geographic territory, or what kind of protection of citizens while they're overseas, or what kind of trade barriers we might agree to take down amongst nations. That's not what modern international law is about. What modern international law wants to accomplish is precisely what Hamilton told the American people in Federalist 75 was not going to happen, which is that modern international law wants to use treaties to change domestic law to affect how citizens within our own nation or within any nation are in fact governed. And you need look no further for proof of this than a recent case that was just heard by the Supreme Court. It's a case called Bond versus United States. For some of you who are in my con law class, you've heard me mention it a couple times. This is actually Bond 2. This is a case that's wound its way to the Supreme Court twice now. Bond 2, which just had oral arguments about a month ago in the Supreme Court, involves an interesting fact pattern. The defendant Bond was criminally convicted of violating a federal statute. And the federal statute was called the Chemical Weapons Implementation Act. The Chemical Weapons Implementation Act was a law enacted by Congress that was an attempt to bring some sort of statutory life to the Chemical Weapons Convention that had been ratified by the Senate. And as that convention sounds like, it's a chemical weapons convention. It was designed to sort of say what signatory states would do in terms of using, stockpiling chemical weapons, right? That's the Chemical Weapons Convention we just made Syria sign, right, recently. Okay, so here's this lady, Bond. She's in, I think, Pennsylvania. And her husband's having an affair. And she's mad, obviously. And she finds out who the paramour is, and that individual happens to be pregnant, and that makes her even more mad. And she says, I'm going to poison her. So she takes a poison, and she puts the poison on, like, the car handle, the doorknob, and various places this woman is likely to put her hands and then, touch her face and her mouth. And she slowly starts trying to poison her. And they find out that she's doing this. She gets busted. And the feds step in. And they prosecute her under this Federal Treaty Implementation Act that was supposed to do, make the Chemical Weapons Convention work. And the question in Bond, you can just see, right, is whether we can use the treaty power along with statutory implementations of an exercise of the treaty power to govern what we do as people domestically here in the United States, whether it can be used to basically supplant domestic criminal law. Is that, in fact, a valid exercise of the treaty power? If it is, I would be worried, because the treaty power then can be used to do all kinds of things we never thought it could before, and the use of domestic law will dwindle over time because everything will just be replaced by superior international law. So the Supreme Court's going to really have a difficult question and figure out the reach of the treaty power. I don't know how they're going to come out. I think they may avoid the constitutional question altogether because they have a statutory way out. But we'll see. It could be a very big case. It's something you should probably watch and be aware of. Okay, so I've already told you that I believe the modern international law agenda isn't about trying to prevent war or trying to make war more just. It isn't about trying to save the whales. It isn't about trying to achieve justice really at all. It's about trying to alter domestic law. And it's about specifically trying to alter domestic law that doesn't comport with the agenda, the political, ideological agenda of people who are so adamant about international law. Things like environmental protection. Environmental protection treaties aren't about hugging trees. It's about cap and trade and wealth redistribution. Do some reading on it and tell me I'm wrong. Death penalty, abortion, gay rights, parental rights. These are the directions that modern international law is trying to go. None of these are sovereign-to-sovereign relations. These are all about domestic matters. So this desire to create or achieve international norms is creating pressure on the court. You need to look no further, again, than the Supreme Court of the United States, and specifically the left or progressive wing of the United States Supreme Court. A couple of cases come to mind. You probably have read some of them. One, Roper versus Simmons. If you've had exposure to that one, it may be in a crim law class or maybe a crim pro. This is the case where the Supreme Court in 2005 basically said that the death penalty for 16 and 17-year-olds violates the 8th Amendment's prohibition against cruel and unusual punishment. It reversed 180 degrees, the Supreme Court decision to the contrary, just about 15 or 16 years earlier. So they did a 180-degree turnabout in Roper on juvenile death penalty. Second case, Lawrence versus Texas from 2003. Everybody who's taken my common law class anyway has read Lawrence versus Texas. That was the case where the Supreme Court found that Texas's homosexual sodomy prohibition violated the substantive liberty component of the Due Process Clause. Right? Now, the reason I'm citing Roper and Lawrence is because they stand out as unique in terms of their analytical structure. Both Roper and Lawrence, the 5-4 majorities in these cases, these living constitutionalists on the courts, showed that they're not only open to, but in fact eager to use international and foreign law to help them interpret the U.S. Constitution. Now, there's nothing wrong with knowing what the rest of the world is doing. Okay? If you're engaging in an academic exercise and you want to do comparative law, for example, and compare how the United States, ponies up to other nations, are we weirdos or are we normal or whatever, there's nothing wrong with that. It's good to be intellectually curious about the rest of the world. But I will submit to you that I think there's something very wrong about looking to international or foreign law to aid U.S. constitutional interpretation. The task of a judge to interpret the meaning of the Constitution is to look at what is understood by us. If you're a living constitutionalist, then us right now, or if you're an originalist, then the us that wrote and ratified the original language. So what South Africa or what Germany or what Brazil thinks about abortion or juvenile death penalty or gay rights is not relevant to this task of U.S. constitutional interpretation. Besides, think of it this way. If you think it's okay to use U.S. or foreign law to interpret the U.S. Constitution, think how inherently subjective you're going to be as a judge. Think of the opportunities for the frolic and detours that you can go on. Because as a judge, you'll get to pick and choose which country's laws, which international law, which foreign law you're going to use to bolster some decision you probably already made in your mind. All right? Think about it. Should courts use all countries' laws? Should they get out a big chart in the conference room of the Supreme Court and have every country in the world listed on the chart and have little, marks as to whether or not they allow or don't allow abortion before we decide if our own Constitution allows abortion? Well, or should we just consider some countries and not all of them? Maybe it's not a raw polling mechanism of all countries in the world. Maybe it's just some of the countries. But which ones? Is it English-speaking countries? Is it Western countries? Is it Judeo-Christian countries only? And how do you know? Then what do you do? How do you rank them? Is an international treaty or convention higher in legal status than foreign law of a particular country like the UK or Brazil or Poland? Which one ranks higher? And where do they rank vis-a-vis U.S. state law? Which one's higher there? I don't know. You can see it's a hot mess, right? It is a hot mess in terms of trying to find a principled method for U.S. constitutional interpretation. Anyway, as you can see, I don't think using international foreign law to address culture war issues is allowed by our U.S. Constitution. I don't think it's in the best interest of individual liberty. In fact, think of it this way in terms of individual liberty. Most of you know I sort of self-identify myself as a libertarian, which means if the question is, do you have liberty or not, generally my answer is yes. Right? But one of the great things about having a globe that's full of distinct nation states is that we have a meaningful choice about where we want to live and what laws we want to live under. It's the same thing with federalism, right? When we teach federalism in con law class, we say that's one of the great things you get about federalism is the ability to vote with your feet, so to speak. Alabama has crappy laws that are really important to you and California doesn't. Well, move to California. Get out from underneath that law that you find oppressive. But if you think about what international law is doing, globalizing, this push toward globalization, especially of domestic law, it's squelching our basic freedom. It's imposing a one-size-fits-all legal regime that no one will be able to escape from if it's ultimately successful. And I don't know about you, but if I have a problem with governments trying to do something that I think they don't have a right to do, the last thing I want to do is try to seek relief from some sort of politically unaccountable bureaucracy in Brussels or Hamburg. It's bad enough trying to call Washington, D.C. and get an answer. If you don't believe me about this democratic deficit and this problem that it's going to create in terms of our ability to control our own governors, ask an ordinary European. Europeans know about the democratic deficit. Okay, the European Union has increased frustration amongst Europeans about their own inability to influence the decision makers. Oftentimes the decision makers are in Brussels. They don't even know who they are. They don't know their names. Much less can they boot them out of office because they're not even democratically accountable. So globalization and internationalization isn't always the solution. Sometimes it's the problem in a very real and deep sense. If you care about democracy, I would suggest that you think that globalization of anything should be your absolute last resort. And as our founders understood, breaking up government into lots of little pieces is in fact a very good thing. Consolidating power is a bad thing. It leads to tyranny. It lessens individual freedom. So the bottom line, sovereignty, a good thing. United States sovereignty in particular, a very good thing. Because we have a great rule of law, we should resist as much as possible the internationalization of law and not be apologetic about defending our own sovereignty. Thank you very much. And now let's do questions. So here's how we're going to do questions. I'm going to move as closely as I can to the question and repeat the question so that it will show up on the tape eventually. So Daniel.
I have a question about another Federalist paper, Federalist number 51.
Yes.
And when Madison was talking about the separation of powers, he said specifically that the legislature should be we should give more weight to the legislature and compared to the other branches.
Right.
And so when the legislature chooses democratically to incorporate an international law into domestic law, in essence domesticate international law, is it really going against state sovereignty?
No, I don't. The question is when Congress, in fact, it's not just the Senate ratifying a treaty by 2/3, but goes further and implements a statute that gets enacted both by the House and by Congress through normal legislative means, whether that's some infringement on sovereignty. Clearly it's not, because at that point you have an ordinary law that's been enacted in the normal democratic ways, right? The question, for example, in bond is not that, to the extent you're raising an issue that some people think is inherent in bond, because we did have the implementing statute passed by Congress. The question is whether or not the treaty ab initio was a treaty that was within the treaty power. And if that treaty is not within the treaty power because it deals with domestic concerns, or could, if interpreted to cover somebody like Ms. Bond, then no statute in the world will cure that, potentially. So it's sort of a fruit of the poisonous tree kind of idea.
And second question, don't we use Blackstone's commentaries all the time to interpret constitutional law? So if we use Blackstone's commentaries, and his commentaries are from England,
yes,
isn't that incorporating international law into domestic interpretation?
Yeah, I don't think so. The question is so we use Blackstone's commentaries all the time, not all the time, but we use them a lot, along with some other English sources, including English cases. when interpreting not only the U.S. Constitution, but just ordinary statutes and the like. And whether or not that suggests that we should open the door to other nations' laws. I don't think so, because even, for example, in substantive due process jurisprudence, the Supreme Court has been very clear that it's our nation's history and tradition. So if, for example, we looked at Blackstone and we saw that Blackstone loved X, whatever X is, and since we broke with Great Britain, no colony in this country had ever loved X, never embraced X the way England did. I don't care if Blackstone devoted 150 pages to it, it would not be legitimate to use Blackstone for U.S. statutory or constitutional interpretation at that point, because it's not part of our nation's history and tradition. The thing that makes Blackstone useful is it's the seed from which a lot of trees sprouted in this country. And when they do sprout in this country, we can go back and see, what seed they came from, and we can go to Blackstone and it can inform us. But that's a very different enterprise from looking to the statutes of Japan and seeing what they think about, juvenile death penalty in interpreting our Eighth Amendment, I think. Come on, there's got to be more questions. Fight with me, yeah.
Professor Foley, I understand your position on international law, and when the majority of the time it fails or questions our sovereignty, but in the position of like the international kidnappings laws,
Okay.
where it creates this like tension between the countries, but I want to see your viewpoint on where these laws they're difficult to implement, and thereby it undermines our authority, and it undermines a lot of superior countries in the world's authority to implement and to actually enforce these laws.
Okay, so back up for me, because I'm not a guru on international kidnapping laws, but you're talking about a treaty that deals with kidnapping.
Basically, an individual kidnaps a child from this country and
Takes it to another.
country.
Yep.
And the countries have a treaty in force
Great.
that says you have to send them back to
It's an
the
extradition
country.
thing.
Right,
Yep.
and it's a jurisdictional matter.
Okay.
So when these countries aren't enforcing these treaties that are in place, they undermine our authority in the international global eyes. So I want to see your viewpoint on how this undermining actually, is it really good to implement these treaties in the first place?
Okay, so we're talking about an extradition treaty leading to specifically dealing with the kidnapping offense, and your concern is that there are some countries that have actually ratified the treaty and yet aren't enforcing it, and that we've ratified it, right, and we are enforcing it, right, and it creates this imbalance internationally. This is the problem of international law, right? I mean, this is why, I hate to be cynical about it, but my position is always there's no there because of sovereignty. Every nation has its sovereignty. Nobody's given up on that idea yet. We've given up bits and pieces in certain, but the only time you really cede sovereignty is if you sign a treaty that takes the decision-making ability out of your nation's and your court system's hands and puts it into some extra-national or international tribunal. And doesn't sound like the kidnapping treaties got that kind of international tribunal. I'm talking about, for example, the ICC, the International Criminal Court. I'm talking about the Law of the Sea Treaty, LOST, which has a strange tribunal based out of Hamburg, Germany, for dealing with deep seabed disputes and any activity that occurs on the international waters. The United States has refused to ratify that. The United States has refused to ratify the ICC too. Same reason in both is because both of those types of treaties represent the cutting edge of international law, which is not to just have a bunch of covenants and promises that rely on good faith, as Alexander Hamilton said in '75, but in fact to create a new higher body, an enforcement authority, a cop on the scene, if you will, an international cop that has the power to do something bad to you, right? The United States has steadfastly said, we're not going to go there because that is ceding our sovereignty. And I think that's a good move by the United States. I would not want the United States to start ceding its sovereignty to a group of people somewhere else in the world. That would scare me. So it sounds like this kidnapping treaty is just a typical treaty, no real way to enforce it, no there. That's the problem of international law. It relies, as Hamilton said, on good faith.
Right, but going back to Hamilton's ideals, I just don't think it's very effective. I mean,
I agree.
so I don't understand, we have to have this international, I guess, good faith, but it just doesn't exist.
No, it's not. But the question is, if you think it's okay to have some international tribunal overseeing the world's kidnapping issues, then it's okay to have an international tribunal seeing all kinds of issues. I mean, there is a major slippery slope problem. And the real question is, do you think that the United States' own legal system is handling kidnappings well? It sounds like you do. You're just worried about other countries, and somehow you want to make other countries behave the way you want them to behave. And I guess what I'm telling you is that's a street that goes both ways. That the rest of the world may want the United States to behave in a certain way the United States doesn't want to behave. So once you enter into that kind of agreement with a supranational authority that has enforcement power, it can be very dangerous for sovereignty. So it may sound good in this instance, but the price you pay long term may be very, very high. So it's a price I'm willing to pay to not go down that road. Yeah.
I have two questions. When discussing members of the left, you mentioned that it's not about hugging the trees or saving the whales.
Right.
Something along those
I like
lines.
whales. Yeah.
I have two questions. The first one is that you're making the claim that in general it really is just more about incorporating the international agenda than the particular topic itself. And two, if so, exactly what scope of people are you talking about? As in, like, your contemporary constitutional scholars or just members of the left in general?
Okay, clarify that last phrase because I was with you till then and then you lost me.
Who did you mean exactly when you said members of the left that wanted to incorporate the international agenda rather than the particular issues?
Again, I wish some of my colleagues who teach international law were here, but anybody who teaches international law? I don't know anybody who goes into international law, at least not maybe practice. I mean, you may be a corporate lawyer who has a strong international component. That's not going into international law. I mean somebody who's into international law, And that certainly would include all academics who grow up to teach international law. There is a self-selection process that goes on in law, right? In the sense that if you're attracted to international law and you want to be an academic who teaches international law, you're probably attracted to that because you like international law. You think it's a good thing. You want to be part of that movement. You like what it's about. So the problem is that there aren't many people who span the ideological spectrum in international law classes. So if you take an international law class, either as an undergrad or as a graduate student, a law student certainly, you're going to get one point of view. It's all good for the most part. And I hope there's somebody in the building here who's defying that stereotype. But I've been to plenty of international law conferences, and it's just a giant, yeah, you're right, Ted. Yeah, you're right, Bob. They don't let people like me come to their conferences. God forbid I wouldn't want to go to them. But that's what I'm saying. I mean, that's why I don't teach international law, right? There's a reason why I'm not teaching international law. God forbid. I don't want to be wallowing around in nothing all day. I'm frank, aren't I? Yeah.
Well, I have another two questions. One follow-up on your question. I think that one of the reasons that international law might actually need teeth is precisely because you have all of these different national bodies accepting treaties and then not actually enforcing them. That's
Right.
the international customary principle of pacta sunt servanda, also exists in contract law. And there's nothing inherently anti-libertarian about that principle, that people should be bound to the promises that they make. And I think when you take it to a state level, I don't think it loses any momentum there. And so I'd say that that's actually an example for why international law should have more influence, not less influence.
Well, let me just fight with you a little bit on that because, I agree that there's nothing inherently anti-libertarian about enforcing your own promise, but you have to realize that in the context of all treaties ratified up till now, other than the ones that have extra national enforcement authorities embedded in them like ICC or LOST, the global understanding is that they're really not enforceable. Wink, wink, nod, nod. Yeah, we're going to sign this. Makes us look good. Wink, wink, nod, nod. And that is our understanding at the time we signed that contract, that it's not enforceable. So you can't go back ex post and suddenly make them enforceable. I agree, though, that if you ratify a treaty with an extra-national or international enforcement authority embedded in it, and you sign up for that, you're signed up, and you're bound.
And a second point, another constitutional provision that seems to me would make treaties, in fact, binding domestically is the Supremacy Clause, because its treaties shall be the supreme law of the land,
Right.
not of the world. It's of our land.
Correct.
I think is the interpretation.
Right, but the
So-
question is, what is a treaty? That was what I was getting at, is what is a treaty?
So if the president, with 2/3 of the Senate, passes a treaty, then that treaty becomes the supreme law of the land.
Correct.
Doesn't that imply that it's the supreme law of
Yeah.
supreme law on domestic land?
Agreed. But the question is, what is a treaty? What did the founders believe the word treaty meant when they gave the president and the Senate the treaty power? And what I'm saying is, at their time, the law of of nations and the understanding of the word treaty was that treaties only affected extra sovereign to sovereign relationships, contractual relationships, not domestic concerns. The treaty power could not reach that far. That was the point of reading Federalist 75 to you. Yeah.
With his first point when he was talking about like when nations don't follow treaties, like for instance when the U.S. signed the genocide treaty where we would step in whenever there's a genocide going on, and then Rwanda
Right.
had their genocide.
Right.
And I mean over talk radio they never wanted to call it a genocide because then we would have to step in. And then you have these tragedies like that happening.
Yep.
While the U.S. on the other hand will go and choose to follow the treaty when it comes to countries like Yugoslavia because we have our own interests in those countries. So I mean, I agree that the international law should have more enforcement power.
Yeah, I mean,
in those cases.
look, I mean, I'm not going to stand here and say that there aren't moments when you wish that the international community would come together and stop atrocities. I think that's the best moment that we could possibly conceive of when the international community would do the group hug and step in. But the question is that really something you can set up ahead of time, prospectively, prophylactically, as a legally enforceable matter? Or is it instead really just one of those moments when the world decides or does not decide to come together and really act, frankly, in an extra legal way to stop something they think is morally wrong? It's not really law per se. It is world, sense of morality coming in to stop something. Think of the Nuremberg trials in that sense. The Nuremberg trials they weren't predicated on some treaty. We just ended a war and we decided we got to do something about these jerks. Let's do something. So we did something, right? And I think we can do that. But it's not really prophylactic rule of law. It is the best global hug you could possibly have. I'm okay with that, but I don't call that law. I call that sort of extra legal moments when we decide by force, by power, to do something that we think is right. And the world will judge whether what we did was right or not. It's a little bit different. It's kind of like the Declaration of Independence. Remember when we did that? That was an extra legal moment, wasn't it? We tried to make it sound really good by printing up the Declaration of Independence and trying to explain to the world why we were breaking with King George. But it was an extra legal moment. And the morality of it or the goodness of it was only judged ex post by what we did as a country and how we behaved.
So if there was a huge movement, international movement, to take our word-for-word Constitution and turn it into an international treaty,
Yeah.
would you say that our Constitution should not be implemented and that we shouldn't get on the bandwagon for implementing enforcement techniques, international enforcement techniques
Yeah,
against
no.
other state sovereignty, even with all our wonderful Bill of Rights?
Absolutely not, because I really believe that nation states are distinct, and every nation needs to have a rule of law that reflects their culture and their norms. I think that's a beautiful thing. Diversity, in that sense, is a beautiful thing. It is good to have different countries, different cultures, different religions have their own way and rule of law. Now, there may be times when the way they do things ends up causing a global uproar and the world comes together and decides to drop bombs on them or whatever. But again, I think that's sort of an extra legal moment, and it may be adjudged as whether or not it was an act of aggression sufficient under the law of war and things like that. But that's different from, should I take the U.S. Constitution and wholesale, drop it on the rest of the world? Absolutely not. And I love the U.S. Constitution, as you know, but that's not one size fits all either.
So, for instance, if there are a bunch of countries that are imposing slavery,
Yeah.
then we should just be like, oh, okay, diversity is great?
Yeah, I think to a certain extent, to be honest with you, that what countries do in their own country is sort of their business unless they're aggressing against us. That's old-fashioned law of war. That's a morality judgment. And again, you may come together with other countries and make a morality judgment that you want to use force to stop their slavery, but that's kind of extra legal. That's not really international law. That's just other stuff. Yeah?
As far as the bond case, you said that once we enter into a treaty, we should be bound by it. So I was wondering about, and maybe a more extreme example, where you do have a private citizen that's actually like manufacturing chemical weapons on a larger scale. Do you think it should kind of apply there?
No, I don't.
Citizens, or still no?
I don't, actually, because I think somebody who's, mixing meth in their basement or any other combination of chemicals that may be nasty, anthrax, is perfectly capable of being prosecuted under domestic criminal law. I see no reason to have another layer that could create a democratic deficit that is dangerous long term. So if local law can handle it and handle it effectively, why go beyond it? I don't see the benefit. Oh, yes, Bobby.
Kind of a little confused about, there's two issues that you mentioned. Like on one hand, you say that there's no there in international law.
Right.
And on the other hand, there's also like the fear that, well, we're going to cede our individual liberty to it. But for me, it's like, well, you can only believe one or the other, because if there's no there, that's essentially the realist approach of there's no there, because really law is about force. It's like who has the biggest guns, who has the most guns.
Right.
That's what law is.
Right.
But on the other hand, you made the argument, well, we're going to cede individual liberty, but are we really ceding individual liberty when we have so many guns and bombs? Like,
Yeah.
you can't, like, how do you hold both positions?
Yeah, actually, that's a very good question. The question is, how do I sort of reconcile the idea that there's no there with my specter that I'm putting before you, that you're going to lose your liberty, if you see. It's a good question. The way I would answer it would be this. There's no there for the most part today. I mean, if you're taking international comparative law, you've already probably reached that conclusion yourself as a student, like where's the beef kind of thing. But there are moments, and the trend and the pressure of the internationalist unabashedly is to put some there, to start creating extranational, international bodies, enforcers, tribunals, cops, administrative agencies that can levy fines, things like that. When you start creating enforcers at the extranational or international level, then there's there. And that's what I'm worried about.
Yeah. But like you mentioned, a good example of that is like the ICJ ruled against the United States government in Nicaragua for sponsoring terrorism and teaching the the revolutionaries there how to
we were like,
torture.
Yeah.
And then we're just like, well, take your tribunal.
Oh, we're so bad.
It's just a piece of at the end of the day, like when you say tribunal, but all they're gonna push is a piece of paper.
Right,
Like,
I know. It's like being reprimanded,
yeah.
right?
Not
At work or something. You're like, oh.
reprimanded by somebody that doesn't matter. Like,
Right.
it's even,
Right. But again, I think that is sort of a wonderful moment for sovereignty, especially sovereignty for the United States. Because I think the United States is a good country with a good rule of law. I think we do things in our best interest, which all countries in this world should do, and that sometimes the rest of the world won't agree with this, and who cares?
But that's I guess essentially my question. Like, what's the when you say that we give up liberty, like what's the there? Like, how does the internet, like, are our guns going to disappear overnight? Or
Well, I mean, there actually was that recent skirmish over the international treaty. I can't remember what they call it about. What's the name of it? It's got some long international treaty name for guns, armaments. And the United States is not going to ratify that because they're concerned that it may have some spillover effect on domestic Second Amendment, right? That it could, if, for example, in this bond case, the Supreme Court does not overrule that Missouri versus Holland case, that we might have a situation where in the future we could ratify that treaty, and that treaty could trump the Second Amendment. I mean, wow, that would be an interesting moment for our sovereignty. A moment where I think I'd move to the island somewhere where there is no law and I could just be an anarchist libertarian. Yeah.
So my question is that, so accepting the definition of it's a treaty as a sovereign by sovereign agreement.
Right.
Can't a sovereign make an agreement with another sovereign saying that my state and the individuals in it will not engage in certain types of conduct? Like, it's been a while since I took con law, but like the migratory birds thing.
That's Missouri versus Holland.
Thank you.
That's Missouri versus Holland.
So isn't that just like treaty-making power plus necessary and proper clause equals Justice Thomas Cries at night? I don't...
Yeah, no, not necessarily. The problem with Missouri versus Holland, and you're right, that was a treaty with Great Britain that involved basically protection of migratory birds. And the Supreme Court ultimately upheld that against a 10th Amendment challenge. And so what people are concerned about, I mean, it hasn't been used after Missouri versus Holland to do anything nefarious, but people are concerned that if the court uses it again, for example, in the Bond case to uphold this prosecution, that it would send a strong signal that, in fact, you can use treaty law to trump not only domestic law, statutory law, but domestic constitutional law, our own constitution. And that is troubling. Now, the Supreme Court also decided another case called Reed versus Covert. I don't know if you read that one, where it was a plurality decision, and the plurality said that you can't do that you can't use treaty power to trump domestic law or domestic constitutional law in particular. So the state of the law on the question that you pose is not clear, and I'm hoping it will get resolved by bond. But I think they're going to find a statutory way out of this question, and we're going to be left doing this for a little bit longer.
And since I'm still talking, I'd like to, you didn't talk about it, but what are your thoughts on like customary international law? Because I think that's been used domestically in some cases.
Yeah.
Like with torture.
I don't know. I can't figure out what custom is. Can you figure out what custom is? I don't know.
I'll go ask Professor Moreau.
Yeah. I mean, you know, internationalists take that very serious. CIL, customary international law. And I don't know, I took an international law course in law school, and I remember at the end of that, I was studying for the exam, and I'm like, what is that? Who decides what's custom? How long does it take? Who's custom? Who gets to decide it? I don't know. That to me doesn't say law, right? When I say law, and I came into law, and I wanted to teach law, I wanted to teach something that was written down. Right? That was clear. It was either in a statute, or it was in a constitution, or it was in a series of case law, something I could get my teeth into. And I don't see that customary international law is that way. In fact, customary international law, as I understand, it's been a long time since I took the basic international law courses, you know, NGOs can drive it. They can have a big say in what that is. Who the heck are NGOs? Why do we care? I mean, aren't they just the people that want to save the whales? I don't know. But they're not sovereign authorities themselves, so I don't know why we're giving them all this power, this authority to have an influence on something called customary international law that's not even written down anywhere. Yeah.
Well, part of customary international law looks at state consent. You know, so you look at the opinio juris of the state. You look at whether or not their laws are consistent with it, and whether they're constantly acting in accordance with the law. And then the question is, should we hold them to their own standard that they've already been assenting to, since this is a standard that you know, some bizarre, vague, you know, international community sort of supports. But it's really.
But how do they know if it's custom? I mean, that's the problem. Is some international body telling you what your own custom is? Why don't you just decide what your own custom is and be done with it?
Well, it's based in sort of it's natural law, right? It's based in the
natural.
idea.
That's not natural law.
It kind of is. Like think about the idea that you know, certain rights, certain customary international rights are so fundamental that when a state shows that they've recognized this right through their actions, through consenting, through whatever, then we should hold them accountable to their own logic, to their own practice.
And who are you to hold them accountable to their own practice? If they want to hold themselves accountable to their own practice, can't they hold themselves accountable? Isn't that what sovereignty is?
It's basically just holding up a mirror.
If I want to hold up my mirror, that's one thing. If you want to hold up a mirror in front of me and say, you know, pick your nose, that's different. If I want to hold up a mirror and pick my own nose, that's one thing. If you want to hold a mirror up in front of me and say, now pick your dang nose, that's different.
That's why it's unenforceable.
Right. Well, that's what I'm saying. I mean, and it's not natural law. I mean, natural law. I mean, I think you're you're thinking about Thomas Aquinas' conception of natural law. Natural rights theory, which is different from natural law, is sort of Lockean, state of nature, frolicking around naked in the Garden of Eden. And what did you have a natural right to do? But that's different from natural law.
Just
Yeah.
very quickly, I think, a couple more questions? Unless you want to keep going.
No, I don't want to keep going because I think these people probably have already been incredibly patient with me, and I told them it would be an hour. But I'll stay and answer any questions anybody wants as long as you want. Okay,
May I make
but I don't
one quick comment
Yes.
to this gentleman's
Yeah.
comment
Yes.
about the supremacy clause. If you look closely at the language, the supremacy clause, those are instructions to state judges. You didn't have national judicial supremacy until 1819, 1820 in the Martin and Cohen's cases. So, really it was a federal model that the judges in the states were told, when you're interpreting your state case law or state cases, please keep in mind treaties. So we have this concept that the Supreme Court is legitimately exercising national judicial supremacy over the states. And I don't necessarily buy that from an originalist point of view, even from a textualist point of view. So it's really a decentralized system where the state judges and state superior courts, Supreme Courts, will be able to adjudicate those cases. We concede too much to the U.S. Supreme Court, is what I'm
Definitely.
saying.
And they've taken that invitation and run with it.
Right. You want to take a couple more questions, or just?
Why don't, well, again, I thought it was going to run an hour, so I don't want to.
Okay.
People probably made some
Well,
evil
that was an
plans.
excellent presentation. I want to thank you very much.
So what we'll do, if anybody has questions, just come up to me now and we'll